Good evening. Captain Retired Matt Edwards here on the 1st of February with a weekly, what I hope to keep doing, weekly Facebook Live observation post report. Now, I'll continue on with what I've been doing all along, trying to do some of the issues that I've listed on a numbered list that I have put into my files portion of my group observation post. Number 451. Was I eligible for Canada Pension Plan Disability only on my first application? Now, what I'm getting at there is that these people, the government and insurance companies, want you to get Canada Pension Plan Disability to subsidize their long-term disability or their pensions. Now, there used to be a 2 out of 3 year contribution legal requirement that served between 1966 and 1998. In 1998, the government changed it to 4 out of 6 years, which is an effective doubling of the vesting period, the period that you need to have in order to get the Canada Pension Plan Disability, and they figured this would save them money. Now, because they changed it, the first time I applied in December of 2011, I'm not sure I could have gotten it legally, because I had been off of work ever since 2008, basically, so that was 3 years. So I believe the way I've tried to make it like a mental note, that 4 to 6 year rule means you have 2 years in which to apply after you last work. That seems to work in my head. So if you cease to work in 2008, you have to 2010 to get it. If you get out in 2004, like Captain Retired Denis Ouellette, then you have till 2006 to get it legally. Now, what's been happening is veterans have been telling me that they're being pressured into applying for the Canada Pension Plan Disability even though they can't legally get it. Now that might even be criminal, because you're trying to get something illegally, and it's the person that's doing it. They shouldn't be forced into it. That's almost like coercion or extortion. Number 452 is going to be short because I can't remember what it was all about, except it's fairly simple. Get Canada Pension Plan Disability statistics. Now, I probably may get more recent ones because I've done a lot of research in the past, and, for example, the people who apply at the beginning, they have a 35 to 40% chance of getting approved. Now, the RCMP in a 1966, I think, actuarial report for the Canadian Forces Superannuation Pension, or the RCMP Superannuation Pension, they estimated that only 10% of disabled RCMP members will qualify for the Canada Pension Plan Disability. Now, in the 1974 actuarial report, they upped it to 25%. Now, these people who make us apply for Canada Pension Plan Disability to save them money are acting as if we have a 100% chance of getting it. Now, that's the way it is with a retirement pension. You always have to get your pension. It's your property. But the Canada Pension Plan Disability has those rules that they put on there, and they change them whenever they want to save some money, like the 4 to 6 year rule in 1998. Number 453, because I plan on talking about a couple of things I jotted down besides the issues that I'm discussing. Veterans Affairs Canada said they have our back when I saw them at a 2018 August meeting at a town hall, but yet they claw back things, proving they don't have our back at all. Now, you'll often hear military members say, I got your 6. Now, I think that's a fighter pilot terminology. I mean, you can't see behind you at your 6 o'clock. Your head is facing 12 o'clock. So when someone says, I got your 6, they got your back. They're going to take care of you. They're going to make sure that nothing goes wrong. Now, nothing could be further from the truth, because Veterans Affairs Canada, in my case, for example, they said I was hurt in service back in 2012. They put me into rehab, and then, not even a year later, they said I didn't get in touch with them. So because I didn't get in touch with them, they said, we're kicking you off of the program. Now, which is more fair? Having a disabled in service veteran left on the program simply because he was injured in service, or kicking them off because you want to save money. Because all of these programs cost money. But having me in the program, it would have cost them money. It didn't cost them much money because when I filled out the paperwork, I didn't fill it out to their standards. So because they asked questions they had no right to ask, and I didn't want to just say no to them orders, I put down instead of yes and how much, I put down yeah, but I'm getting the long-term disability from Sun Life from my job at CRA, but it's a non-indemnity and contributory insurance, and you can't touch it. Do you get, the public service pension? Yes, I get the Public Service Superannuation Act pension, but it's non-indemnity and contributory, and you are not allowed to reduce my payment because of it, because non-indemnity payments are off limits. You see? I mean, it's simple. But that caused them to get their knickers in on that, and although I was in the rehabilitation program, they never sent a corresponding earnings loss benefit payment. So in their mind, having accurate information about your finances is more important than compensating a disabled in service veteran. Now, later, they said I wasn't hurt in service because I applied again. Later on, I got tired of getting screwed around, so I applied again. This time, the same 5 conditions that they said I was hurt in service for in 2012, this time they said the same 5 conditions weren't caused by my service, which I could say is an absurdity. The same case manager signed her name on it, and if it was good enough for the government in 2012, then it should have been good enough in 2014 or whenever I applied again. Now, enough about that, but I just want to say, because it was actually my cousin, Logan, who asked the question at that meeting, and they assured him that the government would always have our backs. Okay, so I got those points done. I'm going to talk about tax. I know everybody loves tax. I made a post today about the taxation of long-term disability. And it's partially due to the irritation that I have about the lies that the government does for the federal long-term disability plans. So now, I'll use my case as an example. I was a Canada Revenue Agency tax collector, which is why taxes don't make my eyes roll over in the back of my head. And I also was in the military. So I served the federal government, the people of Canada, in 2 ways. I had a civilian job where I collected taxes to have programs paid for, and I served in the military as a logistics officer with 36 Newfoundland Service Battalion as a reservist, evenings and weekends. Now, the thing is that recently I was talking to Sun Life, and they have my backup, and they say that I might have my reserve force pension plan deducted from my long-term disability through my civilian employer. Now, see, that reminds me of something that happened with the Manulife Sissok crowd. Now, getting back to the I was hurt in service thing, well, the Army's long-term disability don't pay the Service Income Support Insurance Plan, Policy 901-102, to a reservist like myself, unless you got hurt on duty. So they denied me all along up until they approved me late, because they said it hadn't been proven that I was hurt in service. So between the time I was released in January of 2012 until I got my long-term disability in March of 2013, they refused to admit I was hurt in service, and they refused to pay me my long-term disability insurance. Now, one of my first arguments was that, hey guys, listen, a regular force soldier, if they become disabled, gets long-term disability insurance automatically on medical release ever since 1999. And you can't treat me any different than a regular force person, okay? If I get medical released and you tell me that I have to prove that I was hurt in service, then you put an additional burden on me. How am I going to prove that I was hurt in service, I told them. If I was in the back of a truck on an exercise and the truck flipped over, I lost a leg or an arm or something, then you visibly see that I'm disabled. But if I have a mental health or some other invisible disability, how am I going to fucking prove it to you bastards? They agreed. So they said, well, send us in proof that you were on duty on a day that a doctor diagnosed what you have, which is a workaround, but at least I could go forward. So they finally approved me. I got my insurance, but then later they cut me off. So I have 2 federal government departments told me I was hurt in service. Now, the service income support insurance plan that I'm always wailing on, not wailing like crying, but wailing like smacking it. They're one of the 4 federal government long-term disability plans, and I and McInnes Cooper represented Dennis Manouche in a federal court 2012 case, and they alleged quite correctly that Manulife was an administrative only provider and that the federal government underwrote the policy. Now, if Manulife had actually underwritten and insured the policy, then Dennis Manouche's case would have been Dennis Manouche versus Manulife. But because it's an administrative service only policy, it ended up as Dennis Manouche versus Her Majesty the Queen. Now, that brings us to, why are they lying to us? So I was posting something today, and I put in there a law in a criminal code about concealing your identity. It didn't exactly fit. I would say it's a pretty loose connection to what I was trying to make. But the government, in its infinite wisdom, passed a law that said that if someone was robbing someone and they concealed their identity, they'd probably get an extra charge, an extra punishment. Now, as an aside, I think that's insane. Criminals don't care about the law first, and then you're only adding extra punishment for something they're going to do anyway. You know they're going to conceal their identity. No one's going to rob someone and then tell them who they are as they rob them. Jesus, they'd get caught pretty quick, wouldn't they? So anyway, why does the government, and not just the government, it's, as far as I can tell, almost all the employers in Canada, they hired an insurance company not to insure, but merely to do the paperwork for their insurance plan. Now, when the federal government wanted to deny it was an administrative services only policy, the DOJ, the Department of Justice, put into the affidavit for Dennis Manouche's case, which I have a copy of, and they tried to deny it was an administrative service only because it has actuarial reserves that are put away to pay future claims. Now, I submit that that is absurd. What really matters in an administrative services only policy is who does the underwriting. That's the main difference. Whether it's insured or not insured, who does the underwriting? If the insurance company underwrites it, and the company bought a policy from the insurance company, then it's not administrative services only. The company underwrites it. They take the risk of property loss. And Bob's your uncle. Now, if, say, the federal government, I work for CRA, and if CRA, through the federal government, hires Sun Life to administer its policy, 12,500G, so the federal government underwrites the policy. Sun Life only handles the paperwork, and they charge the government for their time, sort of like an employee. Then they're lying to me. They're lying to the Canadian public. Because, the government in a democracy is not supposed to lie to its citizens so brazenly. Now, they can come up with all the bullshit they want, like claiming it's not an administrative service only because we have extra reserves put away. Well, does that really matter? Is that really the key point that they're going to hang their hat on? I mean, it's insane. Now, I have in front of me a case that I've relied on for a lot of this stuff. It's called National Bank of Canada, Federal Court, 2005, I believe, and it was after the other case, which was in 2003, in the Université de Laval, Federal Court of Appeal, 2003 case. So in paragraph 5, now this is the government, Canada Revenue Agency, taking National Bank of Canada to court because they wanted employment insurance premiums deducted from the long-term disability payment. In their mind, it's income. So if you have income, they figure they should take out taxes, CPP, and employment insurance. Now, the judge said in paragraph 5, in this case, a number of the above indica are present, like the contract between Université Laval and Assurance Vie Desjardins, the contract between the respondent and Financier Manuvie, Manulife, is an administrative services only contract for administrative service only and not an insurance contract in the normal sense of the term. In other words, Financier Manuvie did not act as an insurer, but merely as the administrator. Now, I don't know why he said it that way, because he just duplicated what he said before. He said the company only represents the respondent. Now, I would point out that this is what you call, in business, in law, an agent-principal relationship. If Manulife was hired by National Bank of Canada, then Manulife is the agent and National Bank of Canada was the principal. Now, the same thing applies for the Canadian Armed Forces. You have Manulife has had the contract since it inherited it from Maritime Life. Now, Maritime Life had it from 1969 to 2003. 2003, Manulife bought out the company that owned Maritime Life, and they ended up with the policy. So, essentially, the federal government is the principal. Now, not principal like in school, but principal like as in the main actor, the main entity. And the agent is the person that the principal hires to do the fucking paperwork. Now, okay, so, which in no represents the respondent, which in no way relieves his obligation for the employer. Now, the thing is, sometimes I have to wonder, do the people that work for Manulife actually know that this is an administrative service only policy? Because it doesn't say so in the policy, in the contract. It doesn't state it openly. See? In this case, National Bank of Canada, they had an administrative service only contract signed between the company and the employer, National Bank. So in this case, all they had to do was refer to the evidence, the paperwork. For the federal government, you'd have to look at the evidence of like who got sued in the Manouche case, who got sued in the Butte Estate case, who got sued in the Bryan, Nova Scotia Supreme Court case in 2012, I think. So in paragraph 6, for example, in the National Bank of Canada case, the judge says, in addition, the group insurance plan is entirely funded by the respondent. So unlike the CISA policy, where 85% is funded by the government, in the National Bank of Canada, the employer paid 100% of the premium. Now, and it bears the financial risk of the plan. Now, that's the definition of an underwriter, who bears the financial risk. Legal proceedings must be brought against the employer and not Financier Manuvie. See, the thing is, now, there is a difference between the government, in the case of the military at least, because in the National Bank of Canada, the judge said, lastly, the respondent and Ms. Messier Lafleur were bound and governed by an employment contract during the period of disability. So, some employers don't terminate people on long-term disability. Some employers leave them bound by contract, and then they continue with their long-term disability instead of paying them salary, because they're not serving the employer. They don't get paid for their services, but they get paid a long-term disability payment. Now, in the Employment Insurance Digest, as an aside, a little detour here, it was noted by the employment insurance people that some employers don't pay a pension on disability. They pay them long-term disability until they reach the age of retirement, and then they get contributions. They get credit for their years of service, even though they were on long-term disability, and they get their full pension at retirement. Now that, if it was done in the federal government's case, would end kind of the pension plan disability and pension clawbacks, because you wouldn't get them. You would continue to accumulate service even though you're on disability. Now, I can find problems with that, but I won't get into it now. Now, here's something I'll mention, seeing I was talking about documents and lying. I don't know the source. It might be the criminal code, or it might be the Income Tax Act or something. But it says, offenses related to documents. Section 125, every person who willfully or negligently makes a false statement or an entry in a document made or signed by that person and required for an official purpose, or who, being aware of the falsity of a statement, and then go down to the charges, is guilty of an indictable offense or something. Now, what I'm getting at is the government has been conspiring. I'll use that word even though people might think I'm a crackpot. Section 435 in the Criminal Code, or 465, look it up if I cared, defines the crime of conspiracy. Now, the crime of conspiracy requires 2 or more people to agree to do something that is unlawful, illegal. Now, Manulife is 1. The Government of Canada is 2, so that meets the definition of 2 or more. And they both agreed to file false documents with Canada Revenue Agency, for example. And that could be the charge of conspiracy. It could also be failing to file truthful, filing a document that is meant to mislead. See? Now this goes back to, well, I get into the administrative service only and I'm going down that rabbit hole, but I can get back to it because I'm going to talk about taxes. I said I was going to talk about taxes. They file a tax information slip known as the T4A. They file it in the name of Sun Life or Manulife. Now, I say it's false, and it therefore needs to be deleted from our files. That, if it works, if the courts agree, then there will be no taxes on the long-term disability because there will be nothing on file for them to base the taxes on. Now, the other thing that I would argue is that this is something that they're trying to do that's dishonest. They're concealing their identity, and I want no part of it. Okay? They can try to say, I can imagine what they will say. Everybody does it. We're not doing anything wrong. Everybody does it. Now, to that, I came up with this analogy years ago. The speed limit is 100 kilometers an hour. You're driving 100 kilometers an hour, and you see people whizzing by you left and right. Well, left mostly. And they don't get stopped by the police or anything. So you decide to go more than 100, and lo and behold, red and blue behind you a little while later, you get pulled over and you get a ticket. You says to the cop, listen, I shouldn't get a ticket. These other people, they were speeding too. And that wouldn't get you out of the ticket. You had to be responsible for your own actions. See? So when you're filing the T4A, first of all, you have to know if it's required legally. So for that, not bragging or nothing, but I've got a head for numbers. Okay, so Section 153(1) of the Income Tax Act requires an employer to file a tax information slip for those employees. Now, they don't say employee and employer, but they say a person. See? But it was in front of a court in 1997 called Sparrow Electric, Supreme Court of Canada, 1997. And the issue was bankruptcy, and the issue was also statutory remittances. And in that, the Supreme Court interpreted Section 153(1) as meaning the employer. So it's not Manulife or Sun Life. They only pay the insurance. They administer the insurance policy. They're not legally bound to send in a T4A form. If they were doing it properly and putting the government of Canada on it, you could make an argument that the employer or the former employer was following the required paperwork. But not when you try to deceive people. See? Now, that's one argument. Now, some of the other things I was thinking about recently is that there's a huge conflict of interest here, and this is why I believe, in my expert opinion, that they deceive us about their identity. Let's say you have a dispute between, a couple of people. Could be the employer, the employee, well, the former employee, the disabled person. And let's say you have an insurance company paying long-term disability and you got a dispute. Well, each party will try to look after their own interests for themselves. So Manulife will look after Manulife's business, the federal government will look after the federal government's business, and Matt Edwards should be able to look after Matt Edwards' business. But when you had the federal government hire Manulife to administer the policy, and in the Manouche case, the judge called the relationship the commercial partnership. He said, why would Manulife care to voice an opinion that was different from its partner in the commercial relationship? So we know, at the court said, we know about the parties. So you have, like I said, the principal and the agent. They form one party. So if I put letters to it, let's say the employer is A, the employee is B, and the insurance company is C. Well, A and C formed a relationship, and therefore you get rid of the C, and they are party A. And then you have party B being the disabled former employee, and you have A, the former employer, who has an insurance company faking everybody out. And if you then have a dispute, each party will look after their own interests. Now you got a two-party dispute, you're never going to get it resolved because nobody's independent. So this is one of the key issues behind why I believe the government continues to kick the can down the road and not admit that there is an administrative service only policy. Now, as an example, the Public Service Healthcare Plan was tendered in 2018, and it was admitted that it was an administrative service only policy in that tendering process. Now, that's not the same plan, but it's still one of the federal government insurances that is underwritten by the federal government and not by Canada Life as the one who won the tender. So, I don't know if any of this stuff will ever get out, but I'm doing these videos to try to make it known, to educate the public, to make people talk to their member of parliament. If they know someone in a similar situation, we get together and eventually our voices should be heard. Now, again, talking about taxes, one of the key things that really pisses me off about taxing a long-term disability recipient is that the law, Section 61F of the Income Tax Act, is part of Section 6. Now, Section 6 is a deeming provision. So Section 5 is about employment income, and Section 6 deems certain things that they list as part of the employment contract. Now, as I stated in a post I made today, you might argue that, you have the deemed the income as employment for the public servants who work for the government in a union, they have a contract. But Canadian Forces and RCMP members don't have an express contract. They don't have an individual contract. They don't have a group contract like a collective agreement. They have an implied contract according to the War Amputation of Canada Ontario Court of Appeal case. So in that case, the judge said that the soldier gives service to Canada in exchange for pay, allowances, and the Pension Act pension. So, but the judges said that it was an implied contract. Now, people like my member of parliament staff, well, I know so-and-so, they're my buddy, they're in the reserves, and they had to sign a piece of paper. That's a contract, isn't it? Well, you can call it what you like, but it's not a contract. You don't have any negotiation. You can't ask for different terms. You can't bargain for different things. I would liken it to an insurance contract. An insurance contract is usually sold as what they call an adhesion contract. And you walk in off the street, you talk to the insurance agent, they tell you the terms, they lay the insurance policy in front of you, and you can walk away or you can buy it. That's the nature of a contract with the Canadian military. Okay? So you still have an implied contract, which is just as binding in a way, just as valid as an express contract, except that it's not an express contract negotiated by the person. There's no room at all whatsoever for negotiation with those things. Now, let me see what else I meant to talk about tonight. Well, getting back to the tax thing, one of the things that pissed me off, even though I wasn't part of the Manouche case, okay? I have a condition called Obsessive Compulsive Personality Disorder, OCPD. Now, that is a condition where you want everything to be clear, black and white, right and wrong, okay? So going back to the deception and faking out who is the insurer and who only administers the insurance, that bugs the living shit out of me, because they are doing something illegal, unjust. That's not right, and it shouldn't happen. Now, when the Manouche case was settled, they paid people damages. There shouldn't have been any taxes paid on the damages. Now, if you want a legal and technical reason why they shouldn't have paid taxes, besides the fact that it was characterized in law as the payment meant to compensate for the injury. But the Income Tax Act, Section 61F, requires two things in order to be taxed. So the government didn't want to look like Scrooges in 1971, so they said, we're going to tax long-term disability. They hadn't taxed it between 1917 and 1971. But after the Carter Royal Commission of 1966 on taxation, they decided to tax long-term disability. Now, they said, listen, we're going to be good guys. We're going to leave a couple of loopholes here. We're going to put in here that if the payment is not periodic, then you don't have to pay taxes, okay? So if the payment comes to you and it's a lump sum, forget about paying taxes. The second one they said was if the employer doesn't make a part of the premium payment, then it is entirely your payment, then it won't be taxable because you paid for the premiums out of your own pocket. Now, here's the problem with both of those issues. The lump sum one only comes up every now and then if you didn't have a payment and then you argue with them and they accepted it and then they gave you a retroactive lump sum, like SISIP gave me a $42,000 payment in 2013 because they owed me a year and a bit. And they hadn't been paying me, so they made the payment to me because they were required to after they accepted that I was disabled under their policy in service. But the Manouche case and the Butte Estate cases, they had a class action, and the settlement, the class action went to court, and the settlement to settle the legal dispute was the money paid in damages. But instead of labeling it as damages and leaving it alone, because damages are not taxable, Income Tax Bulletin 465R2. So Income Tax Bulletin 465R2 says that damages are not taxable. Well, the reason they're not taxable is that they're not income. They're meant to balance the scales from the person who injured someone to the person who they injured. So therefore, it's not income. Now, in the Manouche case, you had people who didn't get their insurance who should have got their insurance. They're the victim. And you had the government who clawed back the value of the Pension Act from their payment, and they are the wrongdoer. So the government screwed those people over, and it ended up in court to settle the dispute. So the money that was paid was not income. It was damages. So first, Income Tax Bulletin 465R2, it should not be taxed as income. And then Income Tax Bulletin 428, where it says that a payment must be periodic, and the law itself in Income Tax Act Section 61F. But then the main thing I want to talk about was the fact that when the government said that the employer must make part of the premium, They were full of shit. Okay, here's why. Back in 1969, there was a case in England called Perry versus Cleaver. And the person who was responsible for the injury wanted to take the disability pension off of the damages. They argued that the person who became disabled did not pay for the pension, and therefore it should be taken into account and reduce the damages for the fucker who hurt the guy. Now, the courts over in England didn't accept this stupid argument. And they said, the man's service, his weekly service, paid for the pension contributions. Common sense, right? Nobody does something for nothing. So that goes along with a 2013 case in Canada called IBM versus Waterman, where the same thing came up. But back to the chronology. So 1969 had the Perry versus Cleaver case, and that service equals cash. Service equals money. Then in 1971, the government decides to change the Income Tax Act and tax long-term disability, but only when the employer makes part of the premium payment. Well, they should have known about that case 2 years before, and they should have realized, based on common sense, that even if the employer makes a payment to an insurance company on behalf of the employee, then that is salary. That is income. Now, if they had given the person the money they earned and then the person sent the money to the insurance company, they would receive tax-free insurance. But the government ignored common sense, ignored precedent, and put into the law that if the employer makes a payment, then we're going to tax it. Now, that's bullshit. But just to go back to the Canadian Forces and the public service ones, I've been working on this stuff a long time, so don't think I'm just pulling this out of my head now, okay? One of the main things why I say that long-term disability can't be taxed is that you included the amount of money that was going to be taxed in their income. Now, people might say, that's not true. Well, if it isn't true, then why did the government do a total compensation report published by Treasury Board Secretariat in the year 2007, covering the period between 1993 and 2003, 10-year period? And they put all of the things in there about the pension contributions and the Canada Pension Plan contributions that the employer has to make and the employment insurance contributions as being basically part of the employee's salary. So you can't have your cake and eat it too. You can't say we paid for that, so, it's part of their income, but then later say it's not. Now, in 2012, the Parliamentary Budget Office put out a report about total compensation, and they claim that the average public servant made $144,000 a year when you put all these things that the government paid on their behalf. See? So I'm not pulling this shit out of thin air. I'm, putting the pieces in the puzzle. I'm looking at what they said here, what they said there. Like, in 2013, for example, the government announced that it would charge taxes on premiums that were paid by the employer to the employee. That proves my point. Now, there's also a rule against double taxation. In a Access to Information Act request that I have for the CISIP policy, there is evidence that shows that provincial insurance taxes were applied to the Service Income Support Insurance Plan. Now, people might say, so what? Well, Canada has a policy against double taxation. So because we have a policy against double taxation, if you paid taxes on the premium, you don't have to pay taxes if you become disabled and you get the insurance. That's the rule. You can't tax someone twice. Either you don't charge provincial sales tax, which the provinces wouldn't like, or you don't charge federal income taxes, but you can't have it both. Now you might say, is that just your opinion? And I'd say, no, it's not. Landry, Tax Court of Canada, 1998, I think. So I get these things and then I bring them up. I try to educate people, but they're not my original thinking, even though it's common sense. You can't tax something twice. No, I don't want to be talking all day, so let me segue into clawbacks. Now, in a 1996 or a 1998 Finance Canada report on tax expenditures, now let me explain what a tax expenditure is. According to the government, it's not the amount of money that they spend of the taxes that they have collected. To the government, this artificial bullshit, as far as I'm concerned, in some ways, a tax expenditure is something that the government could have taxed us, but they didn't. Okay? Now, they said that clawbacks in this tax expenditure report was a form of taxation. So if you apply clawbacks against somebody who's on long-term disability, then you have taxed them once. Therefore, you can't apply Income Tax Act Section 618. You can't, because you've already clawed it back, which is taxation, and we have a policy against double taxation. I mean, this is galling. As far as I know, let me see if I got it 4 times. I think they tax a disabled person 4 fucking times. First, they tax them when they're employed and healthy. Okay? So the insurance is included in their annual income, and therefore they pay taxes on their income. So that's the first time. Then you got to pay provincial sales tax on the premiums before you become disabled. So that's the second time that you get taxed. Then if you get disabled, you get clawbacks before you had to pay taxes on the residual amount. So the clawback is the third form of taxation. And then the fourth one is the Income Tax Act Section 618. So you have 4 different ways that the government taxes the disabled or the person who was healthy before they became disabled. And it's absurd. You can't do that. But here's what I was going to segue into on the clawbacks. You see, first I'll explain what a clawback is, just in case you're not sure. They are known as offsets, clawbacks, reductions, deductions, set-offs. But basically, they get information about you from other payments that you get. Now, because they get that information and then they claim that these things reduce your payment, they reduce the amount of money that you get. Now, I'm going to go back to the taxation again. It's not exactly the same for the federal government, but for a private insurance company, let's use National Bank just for badness because I was using a case. So National Bank has people that are getting long-term disability, and then they force the person to get the Canada Pension Plan disability. Now that means they're going to save on their long-term disability expense because they claw back the value of the Canada Pension Plan disability. Now that means the person hasn't got as much income to declare on their tax forms under Income Tax Act Section 618F. It's against tax policy to claw back other payments, because if the person received their Canada Pension Plan plus their insurance, which they're supposed to get, then they will clearly have more income, and until I get the long-term disability insurance tax fixed, on paper, the government will get more taxes. Okay? So the government, in order to argue that clawbacks are good for the country, that it's good public policy, well, they'd have to get their arguments, their reasoning behind how come it's not in the tax expenditure reports put out by Finance Canada. Why don't you say that clawbacks cause a reduction in taxation because the company reduces their insurance, and because they reduce their insurance, then there's less taxes to be paid, and therefore that's something that we could change if we wanted to by closing loopholes and stuff, if they wanted to. See, the government's in the unique position that they pay all of this money for the long-term disability insurance, and they figured that they're saving more on, if they're aware of the issue I just mentioned. I figured that they would probably, and I wonder if they're stupid to say it out loud, if we asked the government about it, and then they said, well, you know, we save more money on the clawbacks than we do on the taxes that we would have collected if we didn't claw it back. Would they be that fucking stupid to say that out loud? Because there's many more employers out there than the governments. And I would argue, without seeing the statistics, and I might look it up, I think it'd be easy. I think I might have done something like it before. What I would do is look at Stats Canada employment statistics. I would compare public and private sector employees. Now, if there are more private sector employees, like working in the private sector, than there are public servants, then it goes to reason that they would become disabled more often, and therefore the company would save on the clawbacks and not the government, and saving on taxes. So therefore, if they did it the way I say it should be done, the government would collect more taxes by allowing the disabled person to get the money they should get anyway. You see, clawbacks are totally illegal. Totally. Go back to the point I said about Party A, B, and C. There's a conflict of interest there. Why should I, as a disabled former public servant, subsidize the government, my former employer? Why should I let them save on their long-term disability payments through Sun Life? Now, if it was Sun Life actually doing it, I would have a dispute with Sun Life. But Sun Life is only doing it for the federal government. Now, I knew I was going to say something else, and I keep looking at time here and thinking I should shut up, but I meant to mention the double clawback thing and the triple clawback thing. And this happens with the Canada Pension Plan Disability. Let's say we have a disabled veteran, and then they're forced to get the Canada Pension Plan Disability by Manulife. Now, let's assume that they get a Canadian Forces Superannuation Act disability pension. So the Canada Pension Plan would first be clawed back by the Canadian Forces Pension under the bridging. Then the Service Income Support Insurance Plan will claw back both the bridging and the Canadian Forces Pension and the Canada Pension Plan, resulting in a net payment from Manulife on behalf of the federal government, which would be much lower, obviously. Then we bring in Veterans Affairs Canada, and Veterans Affairs Canada takes into account the Canada Pension Plan first, the residual Canadian Forces Pension, and the residual CPPD, long-term disability insurance. So they're trying to get out of their payment altogether. Okay? Not just me saying it. They said it in the Canada Gazette in April 2006. They said we have a generous safety margin because we're planning on clawing back things like the Canadian Forces Pension and the Canada Pension Plan. Now, any reasonable person, if they accepted that clawbacks were okay, they would say, you know, Manulife and CPPD has the right to claw back those things. Well, we don't have the right to claw it back, so we don't have a generous safety margin. The Department of National Defense Insurance has a generous safety margin, but we don't. Now, last point on that one. Veterans Affairs Canada is breaking provincial law. When they take the Service Income Support Insurance Plan into account, Newfoundland, for example, under its Newfoundland Insurance Act, says that no creditor can touch insurance. Now, I'm sure that would include Veterans Affairs Canada. So in order for them to take into account the Service Income Support Insurance Plan, first of all, you'd have to get rid of the no assignment clause in the contract. Because even if we wanted to, we can't assign our CPPD to Veterans Affairs Canada. It's against the contract. But secondly, it's against provincial insurance law. Okay? Because Veterans Affairs Canada will be termed a creditor. And a creditor cannot intercept insurance. It's against public policy. Said this before, but listen, if you had insurance and then somebody could go to court, get a judgment, and then send a judgment to your payment administrator, then the person wouldn't have money to live on, and then they'd go get welfare. Now that would cost the taxpayers money in the provinces. Listen, talk too much. Hopefully I made a bit of sense, and hopefully we'll get this fixed one of these days.